What did Congress mean when it carved out an exception for problems with the mail? In United States Postal Service v. Konan, the Supreme Court read a federal law that lets people sue the government for certain wrongs, but keeps the government off the hook for claims tied to the loss, miscarriage, or negligent transmission of mail. The court said that even if mail is not delivered on purpose, that still counts as a loss or miscarriage under the law's ordinary meaning. So the United States keeps its immunity from these kinds of lawsuits. The court threw out the lower court's ruling and sent the case back, without deciding whether every one of Konan's claims is blocked or which arguments were properly kept for review. The justices split 5-4, with Justice Thomas writing for the majority and Justice Sotomayor dissenting, joined by Justices Kagan, Gorsuch, and Jackson. Stick around, because this one raises a basic question about what kind of accountability you can and can't get when the mail doesn't arrive. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. The Supreme Court decided that the Federal Tort Claims Act's postal exception shields the federal government from lawsuits when postal employees intentionally fail to deliver mail. The case required the court to interpret whether the postal exception, which protects the government from claims arising out of the loss, miscarriage, or negligent transmission of letters or postal matter, covers only negligent conduct or both negligent and intentional misconduct. Konan, a Texas property owner who rents rooms to tenants, alleged that postal employees intentionally withheld her mail for 2 years as part of a harassment campaign, allegedly motivated by racial discrimination. After administrative remedies failed, she sued for conversion, nuisance, tortious interference with prospective business relations, and intentional infliction of emotional distress. The district court dismissed the case, invoking the postal exception. The Fifth Circuit reversed, holding that the postal exception's terms don't encompass intentional non-delivery. The Supreme Court reversed the Fifth Circuit. Frederick Liu argued that the postal exception uses 3 overlapping terms: loss, miscarriage, and negligent transmission. All 3 are designed to protect postal operations from litigation. The government emphasized that, first, historical meaning matters. In 1946, miscarriage simply meant any failure of mail to arrive, without distinguishing between intentional and unintentional conduct. Historical dictionaries and newspaper usage confirmed this broad meaning. Second, loss encompasses all deprivation. The word loss ordinarily means any deprivation of property, regardless of how it occurred. People can suffer loss from theft, intentional acts, or accidents. Third, overlapping terms serve a purpose. Congress intentionally used 3 broad overlapping terms to ensure comprehensive protection for postal operations. This is a belt and suspenders approach to legal drafting. Fourth, practical consequences matter. The Postal Service handles over 300 million pieces of mail daily. Without this broad exception, postal workers would be hauled into court constantly, with people simply alleging intentional conduct rather than negligence to escape immunity. Asha Anand argued that the postal exception protects only against negligent conduct, not intentional misconduct. Her key arguments: first, plain language matters. Ordinary people don't use loss to describe intentional taking. You lose your keys when you misplace them. You don't lose them when someone steals them. Second, there's a surplusage problem. If all 3 terms mean the same thing, why did Congress bother using 3 different words? The inclusion of negligent before transmission suggests Congress was distinguishing negligent from intentional conduct. Third, congressional knowledge is relevant. Congress knew how to write broad exceptions when it wanted to, as shown in other sections of the Federal Tort Claims Act. The postal exception's specificity indicates intentional narrowness. Fourth, contextual limitations apply. Miscarriage suggests accident or mistake, not deliberate wrongdoing. If Congress meant to cover intentional conduct, it could have used different language. Justice Thomas, writing for the five-member majority, which included Chief Justice Roberts and Justices Alito, Kavanaugh, and Barrett, adopted a textualist, historically grounded approach to statutory interpretation. On miscarriage, the majority held that when Congress enacted the Federal Tort Claims Act in 1946, miscarriage of mail simply meant any failure of mail to properly arrive at its intended destination, regardless of cause. Dictionary definitions from that era confirm this breadth. The majority rejected the argument that miscarriage is limited to negligent failures, noting that contemporary dictionaries imposed no such limitation. Newspapers from the era used miscarriage to describe mail that failed to arrive even when caused by intentional misconduct, such as theft or burning. Courts historically used the term without inquiring into whether the carrier's conduct was intentional. On loss, the majority reasoned that loss ordinarily means deprivation of property, regardless of the cause. A person can suffer a loss from intentional conduct as well as negligence. Konan's allegations that the Postal Service converted her mail, meaning she was deprived of the use and possession of the property, constitute a loss of mail. The majority rejected the notion that loss requires inadvertence. On the negligent transmission problem, Konan argued that negligent modifies not just transmission, but implicitly qualifies loss and miscarriage as well. The majority rejected this, applying a principle from an earlier case called Barnhart v. Thomas. An adjective before the final noun in a list cannot be transplanted to qualify the preceding nouns. Congress intentionally limited negligent to transmission for a specific purpose: to foreclose claims involving mail even though nothing went wrong with its transport. On surplusage, the majority acknowledged that all three terms overlap substantially, but rejected the presumption against surplusage as subordinate to the cardinal rule that a legislature says in a statute what it means and means in a statute what it says there. Congress likely used broad, overlapping language to comprehensively protect postal operations from litigation. The majority did not decide whether all of Konan's claims are barred, remanding for further proceedings. Justice Sotomayor filed a forceful dissent joined by Justices Kagan, Gorsuch, and Jackson. Sotomayor argued that the postal exceptions text shows Congress intended to exclude intentional misconduct. Further, even if ruling for Konan means more lawsuits, that is Congress's choice to make, not the court's. The judiciary cannot rewrite statutes because a different rule would have preferable consequences. Her key points. First, the negligent transmission signal is the most important clue. Congress's express inclusion of negligent before transmission is critical. If Congress intended to cover all conduct, both negligent and intentional, it would have either omitted negligent or added negligent and wrongful transmission. Instead, Congress made a deliberate choice to limit only transmission with negligent, implying intentional conduct falls outside the exception. Second, loss and miscarriage ordinarily connote negligence. Sotomayor emphasized that ordinary speakers understand loss as unintentional deprivation. You lose your keys when you misplace them. You don't lose them when they're stolen. The Fifth Circuit correctly observed that no one intentionally loses something. Similarly, miscarriage suggests mistake or accident, not deliberate wrongdoing. Third, there's a shifting perspective problem. The majority, to reach its conclusion about loss, must shift from asking whether the mail suffered a loss, which would be parallel to miscarriage and negligent transmission, to asking whether Konan suffered a loss. This inconsistency disappears if all three terms describe the Postal Service's conduct rather than harms to the mail. Fourth, the postal exception is narrower than other exceptions. Earlier cases established that the postal exception is narrower than broader Federal Tort Claims Act exceptions. Congress could have granted immunity for all claims arising from the mail activities of the Postal Service, but instead identified specific conduct. This specificity indicates intentional limitation. Fifth, contextual evidence matters. Before the Federal Tort Claims Act, postal regulations distinguished between miscarriage and detention. When mail was intentionally held back, regulations used detention, not miscarriage, even though on the majority's reading, miscarriage would have sufficed. This suggests the terms were understood to have different meanings. 6. The historical evidence is inadequate. Sotomayor critiqued the majority's historical examples as weak. The majority cited only cherry-picked newspaper references almost 20 years apart, and at least 30 years before the enactment of the Federal Tort Claims Act, using miscarried, the verb, rather than miscarriage, the noun. The government failed to identify even one example of miscarriage being used to describe mail intentionally withheld or destroyed. Sotomayor rejected the majority's floodgates argument. The 335,000 annual complaints to the Postal Service include everything from rude employee behavior to vehicle parking complaints, not serious tort claims. Filing a Federal Tort Claims Act suit requires exhausting administrative remedies and navigating federal court, whereas submitting a complaint requires only typing into an online form. The Federal Tort Claims Act contains additional safeguards. Liability arises only when intentional conduct is tortious, falls within employment scope, and falls outside the discretionary function exception. Most intentional torts like theft likely fall outside scope of employment under agency law. Litigation tools like Rule 11 and modern pleading standards already prevent frivolous suits and effectively guard against abuse. This case comes down to a simple question. If a postal worker deliberately withholds your mail, can you sue the government? The Supreme Court says no. By reading loss and miscarriage broadly enough to cover intentional conduct, the majority effectively closes the courthouse door on people like Konan, regardless of how badly a postal employee behaves. The dissent's concern is practical. If the postal exception covers everything including intentional misconduct, then there's no legal accountability when a postal worker targets someone's mail on purpose. The majority counters that Congress designed it this way to protect the massive machinery of mail delivery from a flood of litigation. But as Sotomayor points out, the law already has plenty of built-in filters to keep frivolous suits from clogging the courts. What's left is a gap. The government can be sued for most intentional torts committed by federal employees, but not when those torts involve the mail. Whether that's what Congress actually intended in 1946 is now a question only Congress can answer. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.